before we recommence, I just need to correct the record because I led the witness into an error. In fact, the new offence of fail to protect under Section 49C of the Crimes Act relates to a victim of sexual abuse, relates to a sexual offence committed by an adult associated with the current organisation. So you'll recall I asked you that with respect to BDA, for example, where he had disclosed abuse. I withdraw that. It's an adult associated with the current organisation. So that offence may not apply to BGD or BDA. But, sir, I asked you before the break about those issues and you pointed out that the failure to disclose offences would apply in respect to both BDA and BGD, correct?
Mr. Phillip, were you consulted about, in the course of the development of that new offence, were you or your department consulted about that?
The department would have been, but I was in the Department of Health at the time.
At the time that was under development.
Mr. Phillip, can I turn now to issues for children who are at risk of sexual abuse in out-of-home care in the community? You understand, of course, that the Royal Commission is dealing with out-of-home care in some detail elsewhere, and so it has not been the focus of this case study. Nevertheless, there are some issues that I ask you to reflect on. You would be familiar with the Victorian Auditor-General's report of March 2014 that dealt with residential care services for children. Are you aware that one of the major findings with respect to that study was that the residential care system is unable to respond to the level of demand and the growing complexity of children's needs, and the conclusion there was that it had been operating over capacity since at least 2008?
Yes.
Do you agree that one of the implications of that that's operating at overcapacity is that it becomes difficult to make sure that children are appropriately housed with other young people who won't be at risk to them?
Yes, when the system's growing in double digits year on year, yes.
And so that risks returning to a system we had some decades ago where children were being placed inappropriately with other children who ended up being a risk, a threat to them.
Look, I think that is always the case. We do have systems in place around reporting and monitoring and indeed around staff training. But again, we're talking about very similar situations where we have children in what is essentially a place of last resort. They're not there because they want to be there. It's because there are things that have happened in their history that sees them in these places, and also at a time of their life where they're growing incredibly. So for all sorts of reasons, and perhaps more in this setting than in the juvenile justice setting, that trauma-informed therapeutic approach really comes to the fore.
Those residential care facilities have a maximum of 4 children in them, is that correct?
Generally, yes.
And so overcrowding won't be the issue, but it will be an issue if those children are housed with others inappropriately.
So placement
Yes.
is the issue. The appropriate placement, that's the one that goes to the issue of quality.
And is that an ongoing concern for you?
Always.
Is it an ongoing problem?
Not always, but it's the one thing we try very hard to deal with.
The recommendations from this 2014 report, so just last year, there were 6 recommendations that the Department of Human Services establishes alternative affordable models of care with sufficient flexibility to cater for the varying and complex needs of children, actively promotes to children in residential care the processes of making a complaint and investigates the feasibility of establishing an independent advocacy role to support children in residential care, develops performance measures, ensures that residential care staff have necessary skills, qualification and training, identifies systems for processing and collecting and analysing information to better meet compliance demands, and reviews existing demand forecasting approaches. That's a lot of work to do, isn't it, for the department to ensure those children are safe?
Look, yes, and it's not that they're all new things to do, it's how you do some of those things better and perhaps in new combinations. So you get a better picture, a more formed picture of what needs to happen.
One other report which has been done in this space which identifies some significant issues is the Geary report, which came out just very recently in August 2015. It's a report from the Commission for Children and Young People, and its title is As a Good Parent Would, an inquiry into the adequacy of the provision of residential care services to Victorian children and young people who have been subject to sexual abuse or sexual exploitation while residing in residential care.
Yes.
I appreciate it's a very recent report. Have you had an opportunity to review it?
Yes, I have. And in fact, as we are here, I initially thought I'd be on a previous day. I'd arranged for the Commissioner to come into the department, so he's meeting with my most senior leadership in this area, because I've asked him to come and share his deep insights into what is going on. Part of this, I want to change the nature of the relationship between the department and the Commissioner, but also I think when the Commissioner has done a lot of work, not everything gets into a report. There'll be some insights that will help us operationalise things better. So while we're here, Mr. Geary is meeting with my senior team to share those insights and to advise them on some of the things he thinks would work going forward. It is also the case that prior to his report coming out, the government has also moved in this area. They flagged this when they came into government and have put in place some of the things already in their first budget. So it isn't the case that with Bertie's report that we're going to start from scratch, but we've started down that journey. And look, it is really important, I think, for the Ombudsman, for the Coroner, for the Auditor General, for the Commissioner for Children and Young People to provide this oversight of what is a complex and sensitive area where the thing that will kill us is complacency. We have to keep reminding people what is our purpose here. And our purpose is actually dealing with a very complex situation with a complex group in our society that in the past we've paid lip service to. Residential care, though, if I could make one comment in terms of the report, is the smallest part of our system. So I think you had some figures yesterday with Mr Hodgkinson about a number of people. I've got more updated figures as of 30 June this year. Total number of kids in our care is 8,187. I think you had a 7,800 odd figure. Of that residential care, snapshot at the end of June, 441. So it's the smallest part of the system. In terms of abuse, the types of abuse, the larger sort of issues that come up around physical abuse, sexual abuse is actually not the biggest part of the incidents that get raised. Physical abuse, sexual abuse is actually not the biggest part of the incidents that get raised.
Nevertheless, it was identified in the Geary report as a significant factor, wasn't it? Abuse perpetrated by external predators, abuse perpetrated by other children, child to child, and abuse perpetrated by staff on children. He found that, yet again, the child-to-child abuse was a significant factor that had to be addressed.
Correct. The hierarchy, though, in terms of the most significant, in terms of volume, is perpetrators from outside of the residential care group. And you heard from Assistant Commissioner Fontana yesterday. We are doing a lot of work with his group in particular about trying to deal with these people outside who engage in grooming, who are opportunistic, to try and deal with that. It is quite a terrible part of our system. But equally, as Commissioner Geary points out, that child-to-child is also a significant factor.
You mentioned earlier that you wanted to change the nature of the relationship between the Commissioner and the department. Could you outline what you want to change it to?
when we have oversight bodies, it is just my view, oversight bodies who go and investigate these things tend to build a great deal of knowledge, and they have an insight that is not the perspective that the department comes from. And I'm not sure just from the report we actually get the most out of them. And so I think if we're serious about trying to solve the system, let the person who's looked at this really carefully, from their perspective, protecting these kids from an outside perspective, let them come in and help us do this better.
You gave us a snapshot of the children in care, the latest statistics of the children in care. You note that 400 or so are in residential care. Where are the rest of the children?
The largest group, about 51%, are in kinship care. And then we have that's about just over 4,000, and we've got about nearly 1,600 in other home-based care like foster care.
There are challenges, of course, in keeping children safe in each of those different areas. So can I move to an issue that concerns child residents both within the juvenile detention centres and also wards of the state or former wards, children in care? One of the consistent themes for the Royal Commission has been that it was very difficult for children to build a trusting relationship with a case officer if they keep changing all the time. Do you recognise that it is an ongoing problem for the department to both attract good staff but also retain caseworkers?
Yes, and it does move in cycles. And look, this is also from a worker point of view, this is also very difficult work. And so retainment of staff, and not just retainment, making sure they don't burn out and don't get hardened to the task is difficult. We don't have any quick fixes to this or simple answers to it. I wish we did, but it's something that is an issue we have to be vigilant about and keep trying to do better at.
Do you recognise that it is fundamental to the health and well-being of children to try and provide them with caseworkers who are going to be consistent?
Yes.
Do you recognise that it's an important way of keeping children safe from sexual abuse to provide them with some consistency as a caseworker?
Yes, although can I also point out that we need other systems in place,
yes,
because that consistency, that trust, also in some circumstances, which is really unfortunate, are also the preconditions for abuse. We did hear that, so...
If the child is... you've got to make sure the child doesn't get stuck with a bad caseworker.
True.
But if you want the child to develop a relationship with a caseworker, there has to be some attempt at consistency.
Yes.
And you recognise that as an ongoing issue because of the difficulty of retaining staff?
Generally, yes. As a general proposition, yes, I agree with you.
Have there been efforts made in recent times to try and retain good staff?
Yes, we have recruitment processes, the way we try and introduce or allocate cases for staff, but also the sort of mentoring that we provide are all designed to try and improve the work situation for staff so that we can have some more continuity, build some more connection, develop that greater corporate knowledge.
On a related issue, I'd like to raise with you a particular issue that has been brought up by a survivor who's given evidence in these proceedings, but it is not an uncommon story. She has explained that she has her own children who have departmental involvement, where the department was providing her with support and assistance. Because of the abuse that she experienced when she was in Winlaton, she needed particular assistance for her children. When she rang the department asking for a sympathetic ear and some assistance, she raised the issue of the continuing changes of caseworkers, which she had herself found traumatic as a child, and which therefore triggered that trauma when she saw continuing changes for her children. But instead of a sympathetic ear, what she got was a reaction that was hostile and eventually damaging to her because it was thought that she wasn't going to be able to provide good parenting. Do you recognise that the department has not done enough to support former wards who have their own issues which are triggered by abuse when they're dealing with their own children?
I don't know the specifics of the case, and to the extent all the things you've said, I am disappointed in our reaction to it, and I apologise for the disrespect that's been shown to the former ward of the state. I think that is the issue you raise is a general issue as well. That is, how do we ensure that we have the best, most sensitive practitioners dealing with the most vulnerable, be they kids or families? And I think what we have heard through the Commission is the extraordinary trauma that continues, that plays out through life for former wards of the state. And yes, can we do better on that? Yes, we can.
So you agree as a general proposition that former wards of the state, who, even though they do their best in parenting, will be extremely vulnerable in that regard in some circumstances?
I have heard their stories, yes.
And that they deserve the best caseworkers and the most and significant levels of support from the department?
And to the best of our ability, that's what we should try to do.
And do you recognise that that may not always be done in the past?
Yes.
One of the issues for some of the survivors is that their ward files contain that we now recognise to be antiquated and inappropriate. In one example that we've been informed of, a child who was undoubtedly extremely bright was described as semi-retarded. In other circumstances, children who were the subject of severe abuse are described as behavioural problems. In some circumstances, are you aware that that can reflect in the way in which the department deals with them now that they're adults?
Look, I have no doubt that it does influence some people. I would like to think it doesn't, particularly in the modern age, but I'm sure that there are instances, as you have now raised, where people form judgments based on old file notes and react in a way that is inappropriate and not reflective of the current situation. At the end of the day, whatever has been written, we have a situation here where our system ought to recognise the trauma that's there for not only the child but the family, and how do we deal with that?
Has the department done anything to assist former wards of the state who were subject to sexual abuse so that they're training staff in the needs of those wards, former wards?
Look, specifically to the case you raised, no, but in terms of trying to deal with the extraordinarily vulnerable situations that people find themselves in, yes, so we now have, over the last couple of years, we've been introducing a system of senior practitioners and practice leaders in all parts of the state, working with teams, so that we can get a bit more of a professionalised approach to deal with the most difficult cases. So I would hope that our system like that would start to take into account the case that you've raised. But if there are specific cases, I'm more than happy offline to try and find some way that we can deal with that.
Mr. Phillip, these issues are not new. The issues of former wards then having difficulties in their own children, and those of the stolen generation have been known for decades. Indeed, to any caseworker, they are real problems on a daily basis. Why would it only now be that the department believes it has to improve its professionalisation in relation to those matters which are well known and form a very substantial part of your caseload?
I apologise if I gave the impression that we've only just started. The specific thing about the practice senior practitioner being embedded out in regions, that is relatively new, but I think our general approach of becoming much more tuned to what you need to do to assist people with the trauma they've faced has been something we've been doing for a little while. The issue is, as is inevitably the case in government, is how quickly you can take that to scale and how much you embed that into the day-to-day functioning of the department. And that has always been an issue.
And we appreciate that you're making efforts to improve this, and as you indicated right at the beginning, this is an evolutionary process. The whole area of child protection and out-of-home care is. But a couple of things. Do you believe, looking back, that the staff, your staff, lacked a knowledge of the impacts of child sexual abuse on wards and failed to take that adequately into account in their casework?
I haven't spoken to or reflected much on some of the details of past staff practices, so I wouldn't want to slight them too much, but I think as a general proposition, could we have done more to take into account those factors? Probably yes, and I don't restrict that just to child protection staff. I would probably say that right across, including the health system, I think we don't tend to take a lot of those factors into account well enough, even in the medical profession, so in providing holistic care. So I don't think it is restricted to just this part of service provision. I think that is probably true of most service providers. I think it is only in recent years that we are becoming much more attuned to thinking about holistic care. The way even our service delivery organisations are set up, we tend to deal with trauma episodically. We tend to treat them through siloed service streams. Only 2 weeks ago, I was at the Royal Commission for Family Violence, and we were talking about integrated care, which is a theme in health, as it is in social services. And I think it is our greater understanding of what the person who presents to us is dealing with in terms of their life experience, and how do we tailor our services to wrap around them. I think the expectations for too long has been that people will follow our system. They'll go from one service stream to the next because it's their responsibility. Well, I think the nature of government provision today has to be to try and understand the individual, the citizen, and wrap services around them. And I think the point you made, I'm not trying to find an excuse for the question you've raised, because undoubtedly in every one of our service streams, could we have taken account of sexual trauma and all that better? Yes, we could have. But I think there is a more general public policy point here around our service delivery that is playing out.
So you have told the Royal Commission in your statements about the compulsory working with children checks, which are now done for staff, not just staff within the juvenile detention facility, but all staff who are child protection workers. Is that right?
Correct.
Nevertheless, the department will have to remain vigilant about people who work with children.
Yes.
And are sex offenders or become sex offenders, correct?
If they perpetrate, yes.
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 Are you aware of any statistics for child protection workers within the department in Victoria who have been charged with sex offenders?
I think we can get that information for you.
And you're happy to provide that to the
Yes.
Royal Commission?
Yes.
You're aware of a process of compensation for former wards of the state who suffered sexual abuse and other forms of abuse. Are you able to tell the Royal Commission of whether or not there is a process for those compensation claims now that aims to minimise the stress?
Yes, in the last couple of years, we've embarked on a very different settlement process that tries to minimise the trauma that people suffer. It follows the common guiding principles that have been developed between our department and Department of Education in particular, where a number of cases have come forward. Certainly now that process has been in place for a couple of years, and I think is taking some of the, I hope is taking some of the trauma out of the process.
You were aware, as a result of your researches, but also through this Royal Commission, that some of the survivors have had serious difficulties in obtaining access to their ward files.
Yes.
Do you recognise that that can be problematic for a range of reasons, including if they are negotiating claims with the department?
Yes.
You will appreciate, for example, that in the case of BGD, in her files, a number of key documents were missing that she only became aware of as a result of the Royal Commission.
Yes.
Were you here in court during the evidence of Dr Hodgkinson in that regard?
Yes, I was.
Can I ask, just as an example, that the document, which is at BGD 27, be shown to you again? You're familiar with this document, I think, but it is this letter from Ms Lyons, also with the name of Mr Groom, which indicates very clearly that those staff knew of the risk of ongoing abuse by the father, and that letter was the response. What do you say now about that letter having been the response to a recognition of child sexual abuse in 1979?
I'm pretty horrified by it. And I would hope that this would never happen again, for lots of reasons. That is, the system wouldn't do that, but it's just that individuals, at the end of the day, wouldn't do that. I think that is I'm quite horrified by that letter, and I am sorry that that has happened.
You appreciate that that wasn't the only document that was missing from BGD's files when she was provided with it. You agree that that's problematic?
It is.
Is there a process that can come down now? Is there a process of returning to the government when negotiations occurred in circumstances where survivors did not have access to all their files and they become aware of them subsequently?
Look, that is a matter for government, but one of the things that is also part of this Commission's remit is the redress scheme. The current government here has already issued a discussion paper, consultation paper on it, and I understand the Commission is doing a lot of work and can provide some guidance nationally to a redress scheme. So that would be one of the avenues that it might be available.
Are you aware of whether or not, when former wards participate in the redress scheme or compensation scheme, they then receive some assistance to report matters to police, if that's what they want to do?
Look, I'm not aware of how that might work in detail, but I would be surprised if there wasn't some way. And I think, given Assistant Commissioner Fontana's evidence around, SONA and the work that is going on, I would expect that there would be a process continuing to receive information and to undertake investigations.
Just in relation again to ward files, you will be aware that one of the documents that BGD got access to as a result, or became aware of in this Royal Commission, related to being administered Depo-Provera.
Yes.
I'm not going to put this on the screen, but I just ask that it be shown to you. You'll see that there are redactions on that document, but do you agree that that is a particularly sensitive document for somebody who was in BGD's position to find out about?
Yes.
What do you think about the fact that she learned about that document in the course of these proceedings?
Look, this is not an ideal situation, and I think you heard evidence from Dr Hodgkinson yesterday of the way files have been created and files have been stored over decades. We have a plan to try and work as quickly as we can and as efficiently as we can to try and locate things, make sure they're in the appropriate category, and be able to provide information deservedly for people who need them. The reality is that files are often, that we're discovering, files are in cases completely unrelated to what that box is titled. We've just recently discovered a file that we've been looking for since 1999, sitting inside another file completely unrelated to it, in a box that is completely unrelated to what that file should be about. This is highly unfortunate. I wish I could say something different, I can't, and we are working as quickly and as hard as we can to try and bring some order to the system so that when people ask for their files, that they get all of the material.
Do you accept the proposition that for former wards of the state, finding those files and being provided with information relating to their families and health is extremely important for their well-being?
Yes, and I was also struck listening to them, the fact that they don't have photographs. I found that particularly distressing, that they would go through life and not have any of their childhood photographs.
Where files are missing altogether or there is scant information, can the department provide help for former wards who have difficulty getting access to healthcare?
Yes, so yesterday we heard from Dr. Hodgkinson where he, I think, mentioned that there were so far about 20 cases where they couldn't find any material. In most of those cases, though, there is a ward card. And the ward card would signify that the person had been a ward of the state. And I think that would then mean they could get access to services under open place, etc. So I would hope people won't feel that not having the file doesn't mean they can't get access to those services. And in the cases where there is none, because it may be the case that some parents voluntarily had left their children somewhere we didn't know about it, or there may be other explanations. I think there is a process of even a stat deck through open place that might assist in getting services provided to them.
Just in relation to records, can you just clarify one matter, Mr. Phillip? And I think there was some mention of it yesterday in relation to non-government organisations. The vast majority of your out-of-home care in Victoria is delivered through non-government organisations.
Yes.
Does the department have a protocol or a standard that now applies that governs the retention and the provision of information by NGOs to their clients?
Yes, there is. I can't go into the specifics of it, but I'm aware that a protocol exists.
Thanks.
So before I leave the issue, one other matter that's come up in these proceedings is privacy in terms of those files. It appears that in relation to Winlaton, for example, an academic got access to the files for children. What does the department do to ensure that ward files remain private?
Look, I will look into that because that is that on the surface appears distressing. I think our focus should be on giving the maximum amount of information to the people who are actually the subject of this. I think that should be our primary focus. So I will look into the issue of research getting more information than a former ward because I don't think that's right. And I'm happy to look at that in detail.
You accept, don't you, that missing files means missing memories? Would you have an expectation that the department would help a former ward to obtain information about their life at that time, even where individual files can't be located?
Yes, and yes.
So you brought with you into the witness box a particular book. Is it the case that you have made it your business to try and learn about some of the survivor stories?
Yes, I have. And in fact, Leanne Sheedy, who's just left, implored me to read Joanna Penglis, who's one of the co-founders of CLAN, a book, Orphans of the Living. And so I've been reading this, and it's not pretty. I have to say it's been quite distressing reading this. And also it does point to some really, really difficult issues for us as we deal with this. If I may, I read this 2 nights ago where, you know, often the excuses have been made about how times were different then. And this is what is written. Another common response is that times were different then. that people thought differently about what was acceptable behaviour towards children, and we are judging the past by the standards of the present. But times were never so different that it was acceptable to flog, rape and torture children. Yet another form of denial is to argue that because the care system did not intend to produce the consequences that it did, those consequences are somehow cancelled out, washed away. They meant well is offered as a way to gloss over the effect of institutional care on survivors and to deny our right to protest. And Donna Jaggs, who wrote Neglected and Criminal, a book in 1986, prefaces her account of the foundations of child welfare legislation in Victoria with a quote from American social analyst Steve Marcus, which expresses exactly this point. And I quote, "We can degrade people by caring for them, and we can degrade them by not caring for them. And in matters such as these, there are neither simple answers nor simple solutions. Dependents, precisely because they are dependent and often unable to help themselves, deserve more than others to be protected from the unintended consequences of our benevolence and the incalculable consequences of our social goodwill." Reading that, gives you plenty of food for thought, because our system is full of also some good people who get up every day and do their utmost in the best interests of children. And our task is to create a system that encourages them to do their best in the relationship they form with families and with children. And in an ideal world, we'd be doing all of this before kids enter resi care, before they enter a child protection system, enter our juvenile justice system.
Mr. Phillip, you prepared your statements without having heard all the evidence from the survivors. You have, as you told the Royal Commission, sat in court for much of the evidence and listened to other evidence.
Yes.
How has that affected you in the way you did your job?
Look, it has been extraordinarily distressing hearing this, the evidence. And it takes me to a couple of points. One is, I came to Australia in 1980. I lived through the 80s, and it was only with Senate inquiry that I really started to hear about this. So how can we grow up in a country as open as this and not really know? So I think that is one of the things that this commission and sitting here has made me reflect on. How do we, warts and all, tell the story of our people? Because if people don't hear it, they won't be attuned to the issues and we won't improve the system. The second thing that I reflect on, and it's not uncommon to just the issues that are being dealt with here, it goes to some broader issues. We have some complex issues in our society. How do we deal with them? The service streams that we are talking about here and their failure is at the pointy end of it. And so how do we provide services in a much more devolved manner to families where they are, in a manner that allows them to maximise their potential and have good, happy families? That, at the end of the day, is our objective. No matter what we do to our system, unless we do something at that front end, in terms of primary prevention, we are going to be here for too many times. The child you raised out of home care, in the last 35 years or so in Victoria alone, there have been nearly 20 major reviews, audits on implementation. You've cited a few, and specific reviews. This is an area that doesn't suffer from the lack of reviews and oversight. And I think it's because the problems are much more complex. And to the extent that we keep putting band-aids on, we'll never resolve this issue. And by resolve, I don't mean have it go away for good, but find ways of dealing with them in the community, in families, before they become real issues.
So do you recognise that one of the ways to protect children from sexual abuse in care is to make sure they don't go into care in the first place, or to try and prevent them going into care in the first place by supporting families?
Possibly, but we do know there are problems in families too, so I don't want to to deny that. Yes.
So finally, the work of the Commissioner for Children and Young People and other reports have pointed out that there is still much work to be done by the department to ensure that children are safe. Has the Royal Commission made you reflect on some of the priorities for you in your term as Secretary?
Yes, and I think one of them is this important emphasis on prevention and what that might mean, how you intervene early and how you build a much more seamless system around health, human services and education from before children are born, how you ensure the health and well-being of families, to maximise the birth of a child, to ensure that children are born healthy, and how we wrap services around what is an incredibly traumatic time for mothers and fathers and other siblings. To the extent we can do that, we will find a better way, I think, to minimise some of the issues.
In terms of practical outcomes for you at the Royal Commission, have you got some priorities that you're going to focus on, and could you tell us about them?
So we have, coming out of also the parliamentary inquiry in the betrayal of trust, there are some initiatives that the government is committed to that we need to be very, very vigilant about implementing. One is the Safe Standards scheme, which I think has been raised in the Royal Commission previously. The second is the Reportable Conduct Scheme. This is very important. It takes the whole issue of reporting much, much broader into the community because it is not just in schools and certain places that we find this, but right across the board. And I think coming out of this inquiry, dealing with redress will be a really important issue. We are doing a whole lot of things now to try and safeguard the system. We've been fortunate this year to have a 70% increase in our Child Protection and Family Services budget. How we use that wisely is going to be really important. We have spot audits as a new thing in our system to try and go into places and make sure they're doing the right thing. So these are some of the priorities in terms of implementation that we want to get cracking on.
And you've heard about the importance for former wards to get adequate support in their parenting and grandparenting roles, and you recognise that there may not be enough done by the department in the past to assist former wards in that regard. Are you prepared to make that a priority in your term? And
certainly coming out of this, yes, and we will also look to some of the advice that will come out of the Commission about things that we may not have thought about to that extent, yes.
Is there anything else, sir, that I haven't given you an opportunity to say?
Look, thank you. In my opening remarks that you allowed me the opportunity to make in terms of the apology, I had written on my notes last night something which I'd failed to transmit into my new version I printed out this morning, and that was I've sat in the gallery every day, and I know there have been people who have survived our centres, and not just the three that have been the subject of these hearings, but we have had others, Hillside, Allenby, and they've been here every day. And I wanted to make sure that my apology was not just to those who provided witness statements, but that I do recognise there were others who've been here every day, and my apology is directed to them too.
Thank you. Nothing further.
Mr O'Brien? No. Anyone else at the bar table? Mr Over?
Yes, I represent Mr Cummings and Ms Short. I just had a question about the provision of medical services, contemporary provision. I understand that the department contracts with the Youth Health and Rehabilitation Services. Is that correct?
Correct. This is in the Youth Justice
facilities.
Yes.
Yes. And you gave some evidence about how decisions are made by a child who's in care and a doctor, and as I understood it, you pointed to the general problematic nature of that out in the community, but also within the department, that it's a decision between the child and the doctor. Now, one of the things that's an issue for my clients, and this goes back to the early 1970s, is that that's what happened to them in the sense that they were effectively provided with medical services where they were asked to express an opinion, and they say that said they didn't consent, but they still had medical treatment. And so the concern that I'm raising is really, what sort of training do these doctors and nurses which provide, what sort of training do they have about respecting young people's consent?
Look, I can't comment on specific things except to the extent from my prior background. I do know that as part of the university training and as part of the ongoing professional development, that, for instance, the Royal College of GPs has previously done work around the issue of consent. So I don't know any specifics today, but I am aware that in various training programs that medical practitioners go through, that there have been modules around this.
And you'd agree, though, that there may be a need for specific training if these people are providing services to a particular cohort which is perhaps more difficult than the general community?
I'm happy to look into that.
Also, are you able to say whether there's any child advocate that attends these meetings between doctors and children to help with these issues?
Normally it would be a one-on-one, as it is in the community.
But is there the capacity for a child to bring an advocate to those?
A child is always able to bring a parent, a guardian, an advocate to any medical examination.
Mr. Phillip, the services have been provided by Youth Health and Rehabilitation Services since January 2014. You mentioned at paragraph 166 of your amended first statement that there's a review in place of those services. Is there any particular reason why there is that review?
No, I think it's a standard review. I don't think there's any, I don't recall there being a specific reason for it. But for a lot of our service streams, we do have regularised reviews.
Thank you. No further questions.
Mr. Carl.
Dr. Phillip, I appear for Norman Latham and also BDA. And were you in court when they told their stories?
Yes, I was.
Now, you have advanced to them and the others who've given evidence before this commission an apology on behalf of the department, haven't you?
Correct.
Now, by that apology, do you accept that when Norman Latham was held at Turana in 1962 and 1963, that the department had failed to protect him from sexual abuse?
I think anyone hearing his story could not come to any other conclusion other than the treatment that he received was not in his best interests.
And specifically, the department had failed to protect him whilst he was in the care of the department from sexual abuse by youth workers at Turana.
It would appear so, yes.
Did you hear the evidence of Mr. Cadd, who was a youth worker at Turana between 1968 and 2007?
Most of it online, yes.
All right. Do you accept that in Turana in the 60s there were serious deficiencies in the selection of employees?
Yes.
All right. You spoke about the architecture of Turana screaming containment, didn't you?
Yes.
As it was in the 70s. The same could be said, that is screaming containment, for the selection of persons with armed forces backgrounds and policing backgrounds to work as youth training officers at Turana, couldn't it?
As a general proposition, yes, but I wouldn't have thought that everyone with those backgrounds was necessarily unfit to deal properly with children.
but it's plain enough from the evidence that this commission has heard that at least some of those people weren't fit for the job that they were employed to do, were they?
Clearly, and we heard examples of Mrs. Baxter and the case there. So,
now there were also deficiencies in the training that was provided to those youth workers in Turana in the 60s, weren't there?
the training would not be, in my view, have been adequate for the task at hand.
There were failings in the placement of children who were wards with other children who had behavioural problems or, to put it another way, committed criminal offences.
I think that was just the system. I'm not sure it necessarily was that it was failing what it was meant to do. I think that was the system, that people with both backgrounds were just put together.
Well, that system put vulnerable children at risk, didn't it?
I think it put, yes.
All right. In relation to BDA, did you hear the evidence of Mr. Holland, who had been a childcare officer at Baltara in the mid-80s through to the early 90s? Did you hear his evidence?
Some of that.
All right. And do you accept that at Baltara, during that period of time, there was a lack of supervision? Perhaps I'll put that differently. Would you accept that there was inadequate supervision due to understaffing?
I think inadequate supervision is probably all I could really comment on. I don't have a benchmark for the overstaffing issue.
You accept that there was inadequate supervision of the boys?
Yes.
Do you accept also that there was inadequate training of those childcare officers working in Baltara in mid-80s through to the early 90s?
Training for the care that we would expect of kids, I'd agree.
All right. And do you accept that those deficiencies contributed, well, perhaps I'll put it more directly than that. Do you accept that the department failed to protect BDA from sexual abuse by other boys whilst he was held at Baltara?
Yes.
Right. And you heard that he was also abused whilst he was at Turana in 1993 and 1994, didn't you?
Yes.
All right. And do you accept similarly that the department failed to protect him from that abuse at Turana?
In
1993 and 1994.
Yes.
Thank you. They're my questions. Thank you.
Mr. Carr. Mr. Sherry.
Thank you, Your Honour. Commissioners.
Oh, sorry, just I'll allow you to go last, Mr. Sherry. I just think there's a couple of other members at the bar table who want an opportunity to ask questions.
Your Honour, my name's Andrew George and Dr. Philip, I appear on behalf of Mr. Brian Fitzgerald. In your evidence, you've accepted generally that so far as the 1960s and 70s and into the 80s go, the selection and process of workers within centres and their training was inadequate. That's a summary of your evidence?
Yes.
And what I wanted to put to you is that Mr. Fitzgerald gave some evidence to the Commission earlier that in his experience as someone working in the 1970s, that at that time the department were having difficulty filling positions.
I have no doubt. As I mentioned earlier, employment in this area goes in cycles.
And indeed, he was asked by me about whether that had continued to be his experience over the next 4 decades of his employment with the department. And he said this: "I think it's a high-pressure position and therefore you have a high turnover, so it's not always easy to get who you would always regard as the best possible staff in these positions. In 1979, I think positions were created, like the welfare officer, to actually fill a position, to fill those positions." Do you think that's fair evidence?
That's his evidence. I have no reason to dispute that. He was there.
And in fact, the position of welfare officer, which he filled in early 1979, was a position that he said was created because the department couldn't find enough qualified social workers to fill those positions. So it was a lower qualification position that was created to do the work. What would you say about that?
Look, I haven't looked at the detailed employment practices in terms of creating and filling specific jobs that relate to him, but so I just accept his account of what happened in his case.
Okay, thank you. In your, I think it's called the amended first statement, which is now dated the 26th of August of 2015, I'm just going to go to paragraph 103 on page 34. It's headed reporting to police. And there it details, I won't take you to the paragraphs specifically, but it details the current practices in terms of reporting to police expected by staff of the department.
Yes.
And it refers to a couple of documents there,
yes,
including the Youth Justice Custodial Services Practice Manual.
Correct.
And there's a technical update as well from 2014 that's referred to.
Correct.
Now, essentially in those documents we accept from me that what they say is that to all staff, if you become aware of or an incident of a criminal nature is reported to you, first you must make sure that everyone's safe.
Yes.
And then essentially, secondly, you are to report that to the unit manager or the area manager if it's an out of hours situation.
And if it is something that's reportable to police, you've got to make the report to police. If you are the person there who has heard this, then you are obligated to be the person who fills out the incident report and makes a referral.
All right. Well, if I could just take you specifically then to the document, which is DHS.304.030.00020. And I'll just read from that on the first page of it. It's the heading, it's described as Youth Justice Custodial Practice Manual, contacting the police, and about 2/3 of the way down the page it has all staff. If you see or are made aware of an allegation or incident of a criminal nature is the heading.
Yes.
If I can skip over the 3 first dot points, because I think we're in general agreement there. The 4th dot point is this. After ensuring safety,
yes,
immediately report the allegation or incident to the unit coordinator, unit manager,
yes,
or on-call manager. There's no further dot point to say at that point, and also contact the police yourself, is there?
Sure, I see that, but I would assume that there is another part in it is a rather large manual that would require you to fill out the incident report, and that would be the process of notifying the police.
All right. Well, if we can go to the second page of that document, under the heading Unit Manager. There we are. If you are made aware of information about an allegation or incident of a criminal nature, dot point 1, report all allegations or incidents of a criminal nature to the police for investigation. That's what it says there. Now, that's the document that your staff currently rely upon in the execution of their duty. And what that suggests, I put to you, is that the person who a disclosure or report is made to first, what they're advised to do today is to report that matter up the line.
I think very clearly in terms of both of those, in isolation, yes, but it would be the case that the original worker is the one who will start to fill out the incident report, and that will form the basis of the report to police. I don't think it is unreasonable in any organisation that a primary worker brings in their superior into this.
No, I don't think it's unreasonable. I think that's just what it is. I agree with you. That is reasonable. And that's what it says that people should do. The primary worker, the coalface worker, should bring in their supervisor. But
our manual also requires the worker to start to fill out the incident report, and that is part of the basis of the report to police.
Which is made, according to this document, by their supervisor.
Well, the supervisor here does report all those allegations, but what is the nature of that report, and what goes in the report is the incident management report that is filled out by the primary caseworker involved.
And the responsibility to report the matter to police in this document falls to the supervisor. That's correct, isn't it?
Just on reading these two, yes.
Yeah. Okay. Just one other thing I wanted to take you to, and this is the last thing. And you were asked questions, and this is in the questions I want to talk about, paragraphs 154 of that same statement through to 156. And Her Honour and Commissioner Fitzgerald asked you some questions about these statistics earlier, you'll recall. 121 reported incidents that fall into the following categories of paragraph 154. What I want to ask you about is this. At A, category 1, 16. Now, in relation to questions that were asked of you by Commissioner Fitzgerald, you indicated that you agreed that in paragraph 156, subheadings, or subpoints B through to G, they were all criminal offences. You recall giving that evidence?
Yes, that would be, I think I had said that I would expect those would be reported to police.
Yes, and I think you might have agreed, or would you agree with me perhaps, that they're criminal offences? Sexual exploitation, sexual assault client to client, sexual assault other to client, sexual assault staff to client, rape client to client, rape other to client.
I'll stick with that. I would expect that it would be reported to police.
Because they're criminal offences. Yeah? Yes or no?
Well, these are the sort of things that I know I would expect them to report to police.
Okay. And what I don't understand, and it may be my failing, I completely accept that, Dr. Phillip, but there's 29 of those offences or matters that would be reported to police involving sexual assault or exploitation upon children. And yet there's only 16 category 1 matters. So it seems to me, just mathematically, that there's 13 criminal sexual assaults or similar upon children that don't become category 1 matters under the system that currently is in place. And why that concerns me is because when you look at paragraph 108 of your statement, it sets out there what happens to category 1 incidents. So my question to you is,
Yes.
Why is that? Why are 13 of them perhaps not category 1 category 1 reports?
Look, there are probably a couple of explanations. I don't have before me exactly the breadth of definitions of B to F, which may be part of the explanation. And the other is this. One of the things in our system is that we are not yet 100% fail-safe in terms of coding between 1 and 2, and between significant events case notes. and that's the reason why we have an audit of all category 1s and 2s by an external team to the Youth Justice to ensure that our practice around that keeps getting better. Now, that may or may not be an explanation. I don't have a definitive one for you here, but just a couple of things that are possible explanations.
Thank you, Your Honour.
Just looking at the time.
So how long do you estimate you're going to be?
10 minutes.
Mr. Sherry?
5 to 10 minutes, Your Honour.
Just take a break.
Or we'll take the lunch adjournment and return it to